2010-64 on the rights to interpretation and translation in criminal proceedings was adopted in 2010, but the deadline for its implementation in member states of the EU was 2013 October. It's a very important instrument for everyone involved in legal translation and court interpreting, because it's the first time that the EU has tried to adopt, to issue some kind of a uniform framework that would regulate the work of legal translators and interpreters in the member states. The situation in regards to court interpreting varies in different member states. They have different regulations in terms of qualification, who can work as a legal translator, that is, as an interpreter. As a matter of fact, there is no consensus about the term itself. Some countries use sworn interpreter, other countries court interpreter. Secondly, the directive aimed to ensure there is quality of interpretation, because this is essential to ensure fair trial. So the main idea is to provide every suspect, every accused, with a comparable quality of interpretation and translation. It is not enough to have an interpreter in the courtroom, but his or her interpretation has to be of sufficient quality to ensure safe, fair proceedings. In this respect, the directive is very important, and it states explicitly that if the suspect is not satisfied with the translation or interpretation, he or she may file a complaint. This is very important, obviously, and it has consequences for the regulation of the profession. Who can work as a court interpreter? It sort of raises the bar because there is more responsibility on the interpreter if he or she may be actually challenged in terms of quality of his work. As regards its implementation, the Republic of Croatia has transposed its provisions into the Croatian Criminal Procedure Act and the Croatian Act on Minor Offenses. Other countries have done so as well, some to a greater extent, others to lesser. There is still a great variety, great difference in terms of prices, so the fees legal translators, court interpreters get in different member states. I would like to emphasize that there are countries in which, for example, Germany, which have adopted additional legislation to make sure that the directive is transposed to a proper extent. Like Germany, they have an act on the strengthening of the procedural rights in criminal proceedings. And Croatia, going back to Croatia, has done so as well in the Criminal Procedure Act and the Act on Minor Offenses. But what is very important is to make sure that all of us who are court interpreters are familiar with the directive, are familiar with our rights, but also with our responsibilities. And likewise, it would be advisable to make sure that all of those working in the Justice Department system are aware of its novelties, some of the changes that have been introduced in this respect. For example, in Croatia, as of recently, all questionings before the public prosecutor are recorded. And after the questioning, the accused or the suspect is asked if he or she was satisfied with the translation provided, which is very important, right? But of course, on the other hand, this right may be abused, it may be misused, and the suspect may complain about the translation, although it was of sufficient quality.